Let me welcome you to today's presentation on employee accommodations under the ADA with a special focus on the hearing and visually impaired communities. Today's event is captioned in English and interpreted into American Sign Language by certified professionals from Carish and Associates. Our primary audience today are employers of all sorts, business owners and managers, HR specialists and generalists, as well as in-house counsel attorneys and partners at law firms involved to some degree in employment matters at their firms. Many of you are from among our clients all over the US. Some of you are newcomers, and we welcome you all warmly. With Mike's help, today we'll be highlighting legal liabilities using legal case studies resulting from ADA law in employment, with case studies focusing on deaf, hard of hearing, and blind communities in particular. Now, you'll be shown how to navigate avoiding these potential legal liabilities with practical solutions. This event is part of a series called ADA Compliance in Practice, and the series focuses on the relevance of ADA law for the deaf, the hard of hearing, and the visually impaired. Each session showcases the legal and practical implications of individual ADA law titles. In today's meeting, we'll be covering Title I in particular. We strongly encourage your questions. So after viewing this event, you'll be sent a brief survey. The survey will include comments and a questions section. You can also contact me or Michael directly by phone or by email after the event. We really look forward to helping you and answering your questions. My name is Adam Carish. I am the Chief Executive Officer at Carish and Associates. Now, Carish is a company that's headquartered out of the greater Philadelphia area. We conduct hundreds of remote accessibility service sessions every week, and we have been serving the community for over 40 years. With clients in all 50 states and in varying industries and 24/7 in-house tech support, our team is made up of experts in accessibility services and in remote solutions for ADA accommodations, and in particular for the deaf and the hard of hearing and the visually impaired communities. I'm joined today by Michael Torsha, Esquire. He is an experienced employment attorney, a partner at his own law firm, and a lecturer as well. Michael, why don't you take it from here and say hello.
Hello, my name is Michael Torsha from the law firm of Seminoff, Ormsby, Greenberg, and Torsha in Huntington Valley, Pennsylvania. I've been a labor and employment attorney for more than 30 years, and I'm happy to be with you today to talk about the Americans with Disabilities Act. So we'll start off today with an ADA overview, the American with Disabilities Act. As you can see, the ADA was passed in 1990 originally. It's a federal law, which means it applies to all states in the United States. And interestingly, in 2008, there was an amendment to the ADA, which very much enlarged and broadened the scope of the ADA. So things that were possibly not disabilities when the ADA was first passed are now disabilities. Congress made it very clear that they intended to really enlarge the number of mental health conditions and physical conditions that would be considered a disability. The ADA itself is pretty broad and has 5 different sections. Today, we're only talking about Title I, the very first title in the ADA, which regards employment and employment practices. So much of the ADA is very jargon related. There are lots of terms here, lots of different language that all have their own definitions. The first thing that you need to know about the ADA and employment is that it does not apply to all employers. It only applies to employers with 15 or more employees. And even the definition of employees is defined. So employers count as if there have been 15 or more employees for each working day in 20 or more calendar weeks. The point of that definition is if you are a business with 14 employees and you hire one more person, you're not automatically subject to the ADA on the first day. There's a formula here. What's interesting though is you have to be careful that even if you're a business below 15, even though you may not be subject to the ADA, you are most likely subject to a state law or a local law that does protect people with disabilities in the workplace. So it is certainly not the situation that if you are an employer smaller than 15, that you are free from the restrictions and the requirements of providing accommodations to people with disabilities in the workplace. So here we go with some of the jargon. Before employees, before you have to provide a reasonable accommodation, which we'll talk about in a second, you need to know that the ADA prohibits employers from discriminating against what I just said, people with disabilities. But the actual term in the statute is, quote, a qualified individual with a disability. And that's with respect to really any employment decisions. It could be hiring, it could be firing, it could be promotion, it could be basic compensation, it could be a work assignment, it could even be where the physical location someone is assigned to work. So the employer needs to make a reasonable accommodation to known physical and mental disabilities. So that means that the employer needs to know about it. If the employer doesn't know about it, then the employer cannot provide an accommodation. I think that makes some sense. However, the employer does not have to provide an accommodation or reasonable accommodation if to do so would pose an undue hardship upon the employer. And you'll see on the slide here that these terms are bolded. And every time they're bolded, that means that there's literally a whole body of law defining what these terms mean. What are the scope of these terms? So it's not so easy for an employer to say, well, this is really a hardship on me. I don't have to provide an accommodation. You cannot make that assumption. There are many, many case studies, many cases from federal courts that show us what a undue hardship really is. The other reason an employer may not have to provide a reasonable accommodation is if that accommodation poses a direct threat to the health or safety of the employee or others in the workplace. So that means that, for example, if someone asked for an accommodation for a certain device or a certain procedure around a machine, and that procedure would put others at risk or the disabled individual at risk, the employer does not have to provide that accommodation. Again, I think that makes sense. You don't have to provide an accommodation if it's dangerous. That's essentially what that means. So going back to who is eligible for this, what type of employees are eligible to take advantage of the ADA? Well, qualified individual with a disability, as we said, it's a person who, with or without an accommodation, maybe they need an accommodation or maybe they don't, can perform the essential functions. Once again, you see here, essential functions is bolded, it's in red, that has its own set of definitions. A disability under the ADA means that someone has a physical or a mental impairment which substantially limits a major life activity, or they have a medical history or a record of an impairment, or they're regarded as having an impairment. That's an interesting one, right? Regarded as. That means that if an employer believes that an employee has a disability, but the employee really doesn't have a disability, they are still protected by the ADA because they are regarded as or perceived as having a disability. So a person with a disability has to have a substantially limiting condition of a major life activity. We're not going to go through every one of these life activities, but there are many. And you'll see that a major life activity is pretty much almost anything someone does. Walking, thinking, standing, lifting, bending, breathing, eating, performing manual tasks, sleeping, working, reading. All of these things are considered major life activities. And as you can imagine, many physical and mental health impairments affect major life activities. I told you that there was an amendment to the ADA, right? So when the amendment to the ADA was passed, it expanded it even more to include major bodily functions. Congress wanted to make absolutely clear that a disability that affected almost anything that was happening with that person could be a disability. So this is not an exclusive list, but they expanded the definition to include the effect on your immune system, normal cell growth, your digestive system, bowel, bladder, neurological, respiratory, reproduction, circulatory, brain functions. Very, very broad definitions once again. The employer needs to ignore all mitigating measures. Okay, what does that mean? Well, that means that, let's say there is someone who needs arm braces. You know, they need to put braces on their arms in order to walk or in order to balance themselves. And that employee says, well, I have a disability and I need an accommodation. And the employer says, well, no, you don't. I know you have a disability, but you've fixed it. You've remedied it. You've mitigated your disability by your arm braces. Therefore, you, employee, are not disabled. Well, the ADA says very clearly, you cannot do that if you are the employer. You must ignore the mitigating measures. You can't count the arm braces. You can't count what people might have, except for eyeglasses. You can ignore eyeglasses because I think everyone in the country pretty much would be affected in some way. But other than that, someone is disabled, even if they, quote unquote, have fixed it or remedied it. So this includes if they take medication, if they have medical equipment or appliances, if they have assistive technology, if they have reasonable accommodations or auxiliary aids or services, which Adam will talk about in a few minutes. So if an individual has any of those things, that needs to be ignored. They're still disabled. You still need to provide an accommodation. All right, so you've heard the term reasonable accommodation a few times now. What does that mean? Well, a reasonable accommodation can be any change in the way work is usually performed. Many times I hear employers say, well, we can't provide that accommodation. That's not our policy. That's not what we do. Well, that's the point. You're providing something extra. You're providing something different. You're probably going outside of your policy. You're probably doing something that other employees are not getting. That's the definition pretty much of an accommodation. You're getting something special. So you cannot say as the employer, well, you know, we don't do that, or that's not usual. We know that. That's the point. So examples of a reasonable accommodation, and there are many. There could be many, many examples. There are many examples. It could be leaves of absence beyond the normal amount of leave. It could be working from home. Boy, we've learned that, right? That working from home can be a reasonable accommodation. A modified schedule. It could be providing certain assistive devices, actually providing something, a medical device or other assistance to the employees so that they can do their job, even though they have a disability. It could be modifying space. You've all probably seen modified space in the workplace, such as ramps or doors or handicapped accessible bathrooms, those sorts of things. We talked about undue hardship. So again, the employer does not have to provide a reasonable accommodation if there's an undue hardship. And the employer can consider many factors to figure out, to determine whether there's an undue hardship. The size of the employer matters, the number of the employees, the types of facilities, the size of the budget, the compensation and structure of the workforce, the nature of the accommodation, the cost of the accommodation, and whether there's a direct threat, of course. Very often employers will say, well, the employee has asked for a special setup in their cubicle, maybe a special desk, maybe a special keyboard or a chair, or special lighting, or something about the sound of their cubicle. Maybe they need white noise, maybe they can't have white noise, whatever it is. And the employer will say, that's expensive. That's going to cost us $1,000. That's going to cost us $2,000. Well, depending on the size of the employer, that might not matter. It's not cost alone. And you might be surprised at how some of the cases interpret undue hardship, that there could be a significant expense to the employer, but still the employer needs to provide the accommodation because it's considered to be reasonable. What does not have to be considered or cannot be considered is the fairness to other employees. So sometimes employers will say, well, that's not fair to other employees if we provide an accommodation. That's not going to be a factor. The effect on other employees might be. So for example, if it meant that other employees had to do more work or work longer hours, that would be okay, but not just the general fairness to the employees. So the court will consider, again, all of those factors, and including the effect on expenses, as I said, and the employer's type of operation. So the employer needs to consider that, and if it was ever brought to a legal action, to a lawsuit, the court would consider that as well. So through all the jargon and through all the definitions and through all the cases and all of that, all the regulations of the ADA, and again, there are many, we just sort of scratched the surface. Let's keep it simple for the employer with two basic responsibilities. The first thing employers need to know is when an employee makes a request for an accommodation, and there's no magic words, by the way, the employee does not have to say, I hereby make an ADA request. The employee can merely say, I really need this to help me with my job. Once an accommodation request is made, the employer must do two things: engage in the interactive process and then actually provide the accommodation unless there's an undue hardship or a safety threat. The interactive process means, very simply, that the employer and the employee need to have a conversation. They need to talk about it. If the employee comes and says, I really need a different setup in my cubicle, the employer cannot say, no, I don't think so. We're not going to do that. That would not be interactive. That would not be engaging in the interactive process. Even if the employee makes a request that the employer believes is unreasonable, the employer still needs to engage in the interactive process. I cannot tell you how many cases there are where there's an unreasonable request made. What the employee is asking for is not going to happen, but the employer doesn't engage in the interactive process and they don't document it. And therefore the employee has a claim because the employee says, maybe my accommodation request was reasonable, maybe it wasn't, but they didn't even try. We didn't even have the conversation. So engage in the interactive process and document it, and then provide a reasonable accommodation unless it's an undue hardship or a safety threat. And then finally on this section for under the ADA, everyone always asks, what are the penalties? What happens if I don't do it? Well, worst case scenario is that there's a claim made, there's a lawsuit that's filed, a violation of Title I of the ADA, and there could be many penalties awarded by a jury or a judge. Back pay, which is the amount of pay that an employee would get from the time of the trial all the way back to when they left the job. Maybe they were fired, maybe they had to leave. That could be a lot. Front pay, which is money for the employee from the date of the trial or the decision going forward to a reasonable time. How long would they have worked for the employer? That could be a very long time. They can get emotional distress damages. They can get punitive damages, which are penalties. And then you might have to pay, probably would have to pay, the employee's attorney's fees. That could be considerable, as it often is. And then you have to pay your own attorney's fees, which could be considerable and often is. Ironically, providing the reasonable accommodation. I say ironically because the employer doesn't provide the accommodation, and it's ironic that at the end of a whole lawsuit, you may have to pay all these things and provide the reasonable accommodation anyway. So that has certainly happened. So with that, I'll turn this over to Adam to talk about aids for those hearing and visually impaired.
Thanks, Mike. Let me preface this section by emphasizing that Title I accommodations requirements are equally as relevant to on-site recruitment and employment encounters as they are to online or remote settings. So as we discuss in the particular case studies that we've selected, the employer's responsibilities include, but are not limited to, the interview and evaluation process, as well as internal meetings and encounters for the duration of employment. Remember this: upon a specific request by an individual who is unable to access specific content, your institution may be obligated to provide reasonable accommodations. Now, examples for this may include pre-recorded materials like training videos, live events like interviews, in-person or live stream company events, announcements of high interest issues or presentations, video or audio content produced and posted on official channels like your company's website or your Facebook feed or LinkedIn. And finally, legacy content, as exemplified in one of the upcoming case studies. Now, this has probably raised a number of questions for you, but don't worry, we'll dig into the detail in some examples and about the requirements during the case study section of this webinar. Now, the ADA law stipulates a specific list of auxiliary aids and services, otherwise referred to as accommodations. Federal regulation proposes a long list of specific accommodations, but that list includes, in some cases, arcane or outdated recommendations, such as telephone headset amplifiers or simply exchange of written notes. Several, though, are mainstream, they're popular, and they're used commonly in corporations, board meetings, training sessions, as well as in educational settings throughout the United States and by US-owned corporations that are active abroad. Here, in this section, we'll be focusing on outlining 4 of the most universal solutions that are most often provided on-site as well as remotely. So let's emphasize that based on our experience with ADA compliance accommodations for businesses all over the United States, all these examples are equally relevant solutions for on-site employment settings as well as for remote scenarios. So we're going to walk through the 4 that I mentioned. They are real-time CART captioning, transcription and note-taking of pre-recorded audio files, qualified American Sign Language interpreters for on-site and remote, and finally, dedicated services for the visually impaired. Now let's get into the detail. Real-time captioning, otherwise referred to as CART captioning. Now, CART captioning is perhaps the most ubiquitous and inclusive accommodation for deaf and hard of hearing individuals during live events such as interviews or team meetings or board meetings and presentations. CART is an acronym and it stands for Communication Access Real-Time Translation, CART. And it's the process of turning the spoken word into captioned text. Now, CART is provided in real time for an individual or a group of any size in any setting. And the speaker's audio is transmitted from the microphone to our certified reporter, and it's displayed as text on a large video screen, a monitor, a laptop computer, or whatever you select at 98% accuracy, and all that within 2 to 4 seconds. Within the real-time captioning category, we've also included internet captioning and live streaming for live streaming events on the internet, as well as uploaded videos from that stream on sites like LinkedIn, Facebook, or YouTube. We also include meaning for meaning, and this in this category, and this is real-time conversion of speech into summarized text, not verbatim per se, but summarized text for individual viewers. So this service is most often provided for meetings. For example, we do a lot of municipal meetings and business meetings and appointments, as well as in educational contexts. For employers, staff training may also be a relevant case. You may have heard of Typewell or Cprint, and they refer to the software meaning is provided in. And in terms of the end user's experience, what's relevant to you, they are almost identical to one another. In this basket, we would also include broadcast captioning, which requires a specialized type of software and exceptional skills. We most often use our broadcast captioners for programs on TV, as well as live, large-scale public events, or simply if a client requests it. The second category is for pre-recorded audio or video files. Here you have transcription, note-taking, and offline captioning. Now, transcription is the creation of a 100% accurate verbatim transcript from pre-recorded audio or video files. Note-taking, on the other hand, is very popular in corporate or medical services settings. It's the process of taking verbatim or summarized notes from meetings and presenting them in some readable format. When it comes to note-taking, there are myriad formats, levels of accuracy, and turnaround times possible, depending on what you need. Offline or closed captioning is basically closed captioning for pre-recorded materials, and it's used for broadcast or internet videos. The captionings for this type of material can be turned on or off, and hence the name offline captioning. Now, open captioning is similar to closed captioning, but the difference is that the captions cannot be turned off, and some people refer to these as subtitles. Qualified interpreters. American Sign Language, or ASL, can be provided on-site or remotely in a business meeting, lecture hall, or at a live event. You only want to permit trained and RID certified ASL interpreters to cover meetings to ensure the best real-time service available. Tactile ASL, or tactile signing, refers to signing using touch. It is a common means of communication used by people with deaf blindness and is based on a sign language or on some other type of manual communication. Now, keep in mind that the accommodation you select must be attentive to your employees or the candidate's specific needs. For example, some people are late deafened. They're not born deaf, and they may not even know ASL. So captioning would be the better option for them. Those fluent in ASL, on the other hand, they take great pride in their unique language and their culture, and they don't consider captions to be a true alternative to ASL interpreting. So in some cases, as in the case of today's webinar, both is often the best option. As pertains to dedicated services for the visually impaired, I'll present two options in addition to the tactile ASL for the deafblind individuals that I mentioned a moment ago. They are real-time Braille cart, which is what we call Braille cart, and it's provided by a certified expert cart captioner who then connects to the blind individual's Braille reader. This allows for the end user to interact in real time with almost any environment. It's worth mentioning here that real-time Braille cart is not a fully remote service, but if you're interested, ask and we can give you more information. Now, a more mainstream service for the blind is audio description. Now, this service is for visually impaired individuals, and it's basically the process of narrating the actions of an event that are taking place in a video or at a live event. And we provide this service for training seminars, for plays, for theatrical productions, and the like. Audio description is also ordered to enable access to pre-recorded materials or sections of a presentation, such as graphs or spreadsheets or important graphics.
All right, thank you, Adam. So let's talk about two case studies, which I think will drive some of these points home. The first is a case called Knoll versus International Business Machines, IBM. This is the Second Circuit Federal Court in 2015. The first case here with IBM is obviously regarding a very large company, right? IBM. So the plaintiff, Mr. Knoll, was a deaf software engineer who worked many years for IBM. He was provided with ASL interpreters whenever he wanted for meetings and video content as well as CART. But the plaintiff demanded that all intranet videos, all IBM internal videos, be captioned and all audio files have transcripts. So he wanted to take the IBM library of videos and have them all captioned and all audio files transcribed. He brought a lawsuit against IBM to do just that. The trial court, the first level court, decided in favor of IBM, and the plaintiff appealed to the next level of federal court, the Court of Appeals. So in federal court, there's the trial court, then there's the Court of Appeals, and then there's the US Supreme Court. Well, the Court of Appeals affirmed the trial court, which means, of course, they agreed with the trial court. They upheld the decision for IBM, and they determined that the ASL interpreters and CART were reasonable accommodations. And they also determined that requiring the company to caption all videos and provide transcripts to all audio files was unreasonable. That was just too much to make IBM do. This is a very interesting case because IBM probably still has, very close to, 440,000 employees at the time, yet the court held that the accommodation was unreasonable under an undue hardship standard. And the reason we say that is, remember when I spoke before about an undue hardship, and we were talking about the court could consider the size of the employer. Well, the larger the employer, the less likely it's going to be that the court will find an undue hardship. When you have a company that makes hundreds of millions or billions of dollars, it's kind of difficult to demonstrate that something would pose an undue hardship for that company, that it would really affect their business in any meaningful way. Yet the court found that even though IBM was huge, that it would be unreasonable. There were 46,000 video files and 35,000 audio files. That had a lot to do with the court's decision. The courts, I think, were thinking, we don't care how big IBM is. You want the company to hire essentially a team of people for who knows how long to transcribe and to close caption 46,000 video files and 35,000 audio files. That's just not reasonable. Even though it was somewhat of an inconvenience for plaintiff to use ASL, the employer is not required to use the best accommodation, merely an effective accommodation. So the plaintiff was arguing that the best accommodation for himself and others who were hearing impaired or visually impaired would be the closed caption or the ASL. But the court said that might be the best, but that's still unreasonable. And you only need to provide IBM an effective accommodation. So the court that decided this is a 3-judge panel, and one judge, one of the 3, dissented and disagreed, saying that the question of reasonableness should have gone to the jury. So the judge made the decision, and this one judge said, you know what, that's really a jury question for the people to decide, not the court. But he was outvoted 2-1. Okay, that's case study number 1. The second of our 2 case studies is the EEOC versus S&B industry. This is a little different. So case study number 1 was about IBM, a very large company. S&B was also large, but somewhat different facts. 2 hearing impaired, 2 deaf women applied for jobs in the company's cell phone repair facility. So they're applying for a job. They're not a current employee, as Mr. Knoll was with IBM. During the interview, the 2 applicants use ASL, American Sign Language, to communicate with one another. The applicants requested that the supervisor provide written information about the positions for which they were applying. The supervisor initially complied and gave them written information, but then stopped. But then he refused to continue writing information, and then the applicants were rejected for employment. So you can sort of picture this, right? There are 2 deaf women, they're applying for a job, they're speaking to each other using ASL. They ask for written information. Supervisor says, okay, sure, and starts to give them some written information. At some point says, no, I'm going to stop doing that. And then they don't get the job. So both of the applicants filed a claim with the EEOC, the Equal Employment Opportunity Commission. So the EEOC is a federal agency, and you must go to the EEOC before you can file certain lawsuits. So you have to go to the EEOC before you can file a lawsuit under the ADA, as was the case here. So they file a claim with the EEOC. The EEOC decides, yeah, there's something here. There's a claim here. So they agree, the EEOC, it agrees to take up the representation of the two applicants. That's why the case is the EEOC versus S&B and not the name of the applicants. The EEOC says, we believe this is important enough that we'll take this up on their behalf. They file a lawsuit and a settlement was negotiated. So in the first case study, it went to trial and it was even appealed. In this case study, it was settled. It didn't go to a full-blown trial. Under the terms of the settlement agreement, there was a 3-year consent decree, essentially what the EEOC calls a settlement agreement. And the company agreed to do all of the following things. The company agreed to pay $110,000 in total monetary relief. It's a pretty significant sum. The company agreed to post a public notice about the settlement in addition to a public announcement by the EEOC. So in other words, the EEOC made it public that there was this claim and it was settled and the terms, and the employer also had to put it up in their facilities. The employer agreed to provide training for employees on the ADA to include instruction on the reasonable accommodation process. The employer agreed to send managers, supervisors, and human resource professionals to training provided by the Deaf Action Center, a Dallas organization that provides advocacy services for individuals with hearing impairments. So they had to send their managers and supervisors to training, and they were required to keep a written log of all complaints of disability discrimination and then report to the EEOC on a semi-annual basis. That's a lot. That's a lot. If you go back to what happened in the first place, that the supervisor refused to provide written information to hearing impaired applicants, they ended up paying a lot of money. It became very, very public. They provided training to employees, training to their managers, and they had to report to the EEOC on an ongoing basis. So settlements have real life implications. Lawsuits have real life implications. When you don't accommodate a person with a disability, there could be, I mean, other than the fact that there could be a morale issue and that person could be very unhappy and they may quit or they may do a very bad job, which of course costs the employer dollars in terms of those sorts of things. You could get a claim from the employee. You could get a claim from an employee's attorney. There could be an EEOC claim. There could be like a full-blown lawsuit, as we saw. Whether it goes to trial, which is a little unusual. Statistically speaking, claims don't go to trial; they settle. But settlements have real-life implications. Employers are really paying money. Employers are really having to do certain things that they may not otherwise have done. So there are really practical considerations for your institution, for your business, for your agency, whatever it may be. The point here is that comply with the ADA and any other state or local laws that there may be. And it may be a little bit expensive and it may be a little time consuming, but it is much better than getting a claim later on and having to go through a charge with the EEOC or a lawsuit. Adam?
So as Mike mentioned, after a few years of proceedings, each of these lawsuits was settled. Although these cases can't be treated as a specific precedent for other cases, they do give us a useful behind the curtains look at a sample situation similar to ones that your institution could find themselves in. So the silver lining to all this high-profile litigation is that selected accommodations such as CART, ASL, and note-taking have become standards for most employers and for live events and presentations, as well as social media content that they publish. So like many American universities, many employers have already realized that the socially responsible thing to do is to preemptively run an accessibility audit of their operations. It's to establish digital accessibility policies. It's to set captioning quality guidelines for their institution. It's to continually improve accessibility for their company's resources, for the deaf and the hard of hearing, for the blind, and for other members of their business community. These cases are fascinating and they're telling. They expose that accessibility accommodations, especially in the context of employment, don't always offer one-size-fits-all solutions. And that oftentimes employers, HR specialists, disability departments don't know exactly what they need, and they're looking for experience-based guidance. This brings me to our next and nearly final slide about choosing your agency and asking the right questions. Throughout this presentation, I've outlined the most popular accommodations relevant to the deaf, hard of hearing, and visually impaired communities. Carish provides all of them to corporations and law firms like yours, to government institutions, and to universities throughout the country every day, and we have for decades. So remember, when it comes to ADA compliance accommodations, don't wing it. Reach out to us for advice and guidance. There's no need to be apprehensive about interactions that require accommodations if you are prepared. With the right advice and support, adding accommodations like cart captioning, transcription, and note-taking will be a great improvement to your entire organization, not just the deaf, hard of hearing community members that you interact with. Remember as well to ask questions. Ask your agency of choice qualifying questions about what matters to you once you decide to implement accommodations. Here are a couple examples. Will setup and testing support be included in your pricing, right? Will you get access to experienced in-house technical aides who will coordinate with you and with your team members while you're prepping for an important event? And do they have a process to guarantee consistency and reliability? For example, do you get personalized support from one dedicated customer support representative who knows your business well, or is it more of a help desk call center type of solution? Be sure to ask questions and to get answers as you schedule. Well, there it is. We're glad you invested your time with us today. By being here, you've demonstrated that ADA compliance is important to you and that you've begun to take steps towards improving conditions at your workplace, especially for the deaf, hard of hearing, and blind communities, but for others as well. We commend you on that. Now it's time to take positive action. Here are 3 ways you can do that. You can schedule a 12-minute demo. You can ask questions about what you've learned here today, and you can see how accessibility accommodation solutions work in practice, remotely, for example. You can request an accessibility audit of your workplace, and you can get ADA compliant, and you can stay that way. You can just call Mike, and he'll walk you through the process. Or you can just order a service. You can contact us and try us out for an upcoming event. Come back again and join us for our next ADA compliance webinar in this series, and bring your friends.